Hello, everyone. Good afternoon. My name is Ed Barr with Volpe Koenig. I'm here with my colleague, John O'Malley, and we're here to provide a presentation to provide some general information for startups, to give some background about the different kinds of intellectual property protection that are available. This is not intended to be legal advice or to create a legal relationship, and it will almost certainly raise many questions in your mind, but this is a good thing. We're glad to speak with you about any questions that you may have. This is a representation of a presentation that we recently gave at the third annual Power of Intellectual Property and Raising Capital conference. It's going to include, I will do the first half, which will cover patents and trade secrets, and John will do the second half, which will cover trademarks and copyrights. So we're your hosts, and just before we begin, a little bit about Volpe and Koenig. We're a full-service intellectual property law firm. We serve many wonderful, sophisticated clients all over the world. There are more than 40 of us on the attorney and agent side, with many advanced degrees, a lot of relevant industrial experience, former patent examiners such as myself. A number of us have language skills in various commercially relevant languages, and moreover, we have an extensive network of foreign associates so that we can cover your needs anywhere on earth. So just as an overview, again, we're going to discuss patents, trade secrets, trademarks, and copyrights. So just to get started with patents, I'm going to talk about what patents are. I'm going to talk about how they're used. I'm going to talk about how long it takes to file a patent application. I'm going to talk about how long it takes to receive a patent. And I'm going to talk a little bit about budgeting for patents. So as for what patents are, what they are is a right to exclude others from making, using, selling, offering to sell, or importing patented inventions. And I underline right to exclude because patents are not a right to make, use, or sell the invention. It's a right to keep people from doing things. It's not a right to do things yourself. And the reason I draw this distinction is because you, for example, could have a patent on an improvement to something, whereas somebody else might have a patent on the base idea. So it's just something to keep in mind. Patents cover a number of different kinds of subject matter, including pharmaceuticals, new plants, industrial processes, manufactured articles, chemical compositions, electronics machines, new mousetraps, the sort of thing you would think of intuitively as an invention in general. So a little bit about how patents are used. And from the perspective of a startup, this question is really, why are patents worth spending money on? You only have a limited amount of money as a startup. Why is this a valuable use of your funds? Well, the first thing patents are used for is to exclude competitors from the market. This is probably the first thing you think of intuitively if you know anything or have heard anything about patents. You have a patent on something, somebody does it, and you have the right to keep them from doing it. And typically this is done through infringement litigation where you sue them or threaten to sue them in some way. But there are actually a number of other ways that you can use patents in a valuable way for a startup. Another use for patents is to develop alternative sources of income. And what I mean by this is, for example, suppose you've spent some resources developing a new technology that you've patented, but for whatever reason, you're not ready to manufacture it yourself right away. You don't have to let it sit on the shelf gathering dust. What you can also do with a patent is essentially you can rent it. So this is done through patent licensing. So you might, for example, rent your patent, license your patent to your better mousetrap to someone who is ready to commercialize it, and they'll manufacture it and sell it, and you'll get a cut. So you'll be getting an income stream, and you won't even have to manufacture it or sell it yourself. Another interesting use for patents that people don't often consider is as a defensive weapon. Sometimes I call this mutually assured destruction. And what I mean by this is if you have a number of patents and you're in an industry where you have close competitors who are doing similar things, and maybe you also have patents on what they're doing, it's possible that they're looking at you to see if you're infringing their patents. And on the chance that maybe you arguably are in some way, they also have to consider whether they're infringing your patents. And what that means is that instead of jumping right into suing you or sending you nasty letters, they might want to get in touch with you to maybe cross-license the patents or have a more constructive discussion instead of getting straight into lawsuits. Another interesting use for patents, I think, is to demonstrate value. And what I mean by this is essentially marketing. A patent is a really detailed description of what it is that you've developed, what it is that you own and can exclude other people from doing in the marketplace. And so you can actually provide these documents to people to give them an idea of what it is you do and what it is you own in the market. And another thing you can actually do is you can provide, well, actually, what I'll do first is I'm going to show you. This is a cover page of a patent on a better mousetrap. And what I wanted to show you is that this is a picture of the cover page of a published patent application for this patent. Now, patent applications publish well in advance of when they ever issue as patents, and you can actually provide these documents, which are very similar to patents, to your competitors or potential customers to give them that same level of information about what it is you are intending to patent. And that can put them on notice of what it is that you may potentially own, and also be useful for marketing in that sense. So suppose you're convinced at this point that a patent would be something of use to your startup. You probably want to know, how long does it take to get started with all this? Well, the answer, unsatisfyingly, is that it varies, of course. But as a general rule of thumb, we like to say for a non-rush filing of a regular utility patent, probably about 90 days from when we receive a complete disclosure from an inventor. So what I mean by that is you've written out in pretty thorough detail what it is that you have, you believe is your invention, and I could readily understand it from reading it. If you give us about 90 days, that's a good time window, I would say. This could be expedited in some cases in some different ways. There are varying degrees of risk and added costs involved in doing that, of course. One way of speeding things up, if you need to file a patent application in a hurry, and we'll get to that a little later, is that you can file a provisional patent application. These can sometimes be done less formally, so that can limit the preparation time, and also can sometimes be done for less expense, but there are risks inherent in doing that. Another thing that can sometimes be done to reduce the burden on you to expedite the process of getting the information to us is, in some cases, we can come to you and kind of discuss the things that you're doing and try to figure out what might be patentable and what information we'd need. This is something called a patent harvest. So this can limit the preparation burden. So an important thing to note, and I've underlined this because if you don't remember anything else I say from this presentation, I want you to remember this part, is that you need to apply for your patent before the invention becomes public knowledge. There are some exceptions to this, but the exceptions are much weaker than they used to be, and in some parts of the world don't exist at all. So do not rely on these exceptions. If your invention becomes public knowledge before you apply for a patent, you can lose the right to ever get one. So after you've gone through all the effort of applying for a patent, how long will it take to receive an issued patent? Well, if you look at the USPTO's website, at least recently, they'll tell you that the average is about 28.6 months. But this number is actually fairly useless because it varies considerably. It depends on the different art units within the PTO will have different workloads. These art units are different organizations that handle different technologies. How crowded the field you're in will have an impact on how difficult it is to prosecute. And so what that means is, if there are a lot of patents in your field, the examiner will have a lot of options as to what to look at in order to try to make the argument that your invention isn't patentable. So it takes longer to convince them, essentially. But even though this takes a certain amount of time, there are some advantages that accrue to you after filing your application, even before the patent issues. So one thing you can do right away is you can begin marking your products as patent pending. Most people have seen this on different products. It has a certain amount of marketing cachet. It lets people know that you're taking what you're doing seriously. You think there's some novel features to it that other products, other competitors don't have, and that the government is having a look at it for that purpose. As I mentioned before, you could provide copies of your published application after it publishes to potential investors or customers to give them a detailed idea of what you're doing. And in some cases, provisional rights may apply. This is something you would have to discuss with someone like me. But essentially what it means is that you can use that published application, for example, to put potential infringers on notice that you may eventually get rights under patent rights to what you're claiming in the application. And if the patent claims are substantially similar to what's in that application, in some cases, you may be able to get damages going all the way back to that notice period. But this is something you would definitely have to discuss with an attorney to be sure and to make sure that you perfect that right properly. So let's talk about budgeting for patents. A very important question for all startups is how much does this cost? And of course it varies, and that depends on different factors. So one of those factors is how complex is your technology. So obviously, the longer it takes me to understand what you're doing, the longer it takes for me to be able to write it out in a way that other people can understand what it is you're doing will have an impact on and how much it costs to prepare these documents. How completely your idea is fleshed out before you give it to me has an impact on that. If it's very clear, it'll take me less time and cost less money ultimately. But I would want to give you a rough rule of thumb so that you have some idea about budgeting in the current time frame, which is 2022. I would say you should budget roughly 8 to 15K, depending on the technology, how complex it is for preparing and filing the application. I would also say you should budget the same again for prosecuting the application, meaning for reviewing and responding to official communications from the patent office in an attempt to get your application allowed. But of course, these costs can go up considerably if complications arise, and they're essentially unbounded, but these are solid starting points, and it's something you can talk about in more detail with your attorney. So that's it for patents. Let's move on to trade secrets. So as with patents, I'm going to tell you a little bit about what they are, how they're used, how long it takes to file. You'll note there are some asterisks there. How long it takes to receive, also asterisks, and a little bit about budgeting for trade secrets. So what trade secrets are? I tried to stay away from the legal terminology as much as possible, but in the case of trade secrets, it's actually helpful to go through it a little bit. So what they are is it's commercial information not known or easily found out by the public. So this is information about your business that is a secret. It provides an economic advantage by being not generally known. So the advantage you get from it is that it's a secret. And reasonable efforts are made to keep the secret. So you're actually trying to keep the secret, putting different taking various steps to keep it from becoming generally known. So if you can establish those things, you very well may have established yourself a right against misappropriation. This is something you would have to definitely discuss with your attorney, someone like me, to make sure that you've done that properly. So what trade secrets cover are, similar subject matter to patents, cover things like formulas, industrial processes, the secret formula to Coca-Cola, things like that. Can also cover things like business and economic information, which is not subject matter for patents. So how are trade secrets used? In other words, why are they worth spending money on? Well, you can enforce against misappropriation. So if your employee or somebody else inappropriately takes your secret and does something with it, if it's done but through an improper means and you've actually correctly established that it's a trade secret, you may be able to get an injunction from the court and potentially obtain damages. Another good use for trade secrets is as a means for intellectual property protection that hides your advantage from the competitors. And what I mean here is that there's no need to disclose what you're doing publicly with a trade secret, as with patents. With patents, you get a limited monopoly from the government to do something in exchange for actually disclosing to the public what it is you're doing. Whereas with trade secrets, potentially, for as long as you're able to keep the secret, and until somebody else figures it out on their own, in theory, is potentially unlimited term of protection. So how long does it take to get started? How long does it take to file for trade secrets? This heading is only by comparison with patents, and it's a trick question because there's nothing to file for the trade secret, but it does take varying amounts of time to put business practices into place to secure those trade secrets. Remember, you have to be taking suitable measures to maintain it as a secret. So this is definitely something you need to review with an attorney, someone like me, someone like John, but different steps that you might take involve non-disclosure agreements, document protection procedures and policies, security measures, cybersecurity, physical security, training your employees, monitoring and maintenance of all of these things. And so that can certainly take a certain amount of time to get all in place. And so how long does it take to complete the process? Well, there's nothing to wait for from the government, like with patents. However, developing all of those different processes and business practices, as I mentioned, does take a certain amount of time. So that's a little bit less predictable maybe than patents. So a little bit about budgeting for trade secrets. Once again, there's nothing to file with the government, so there are no fees or prosecution fees. However, developing and implementing those protocols, as we mentioned, will obviously have associated costs. So with trade secrets, potentially you have a lower cost than with patent protection, but maybe not. And there may be more uncertainty, and then the risks are different. Once again, balancing these risks is a business decision that you'll have to make in consultation with an attorney who can guide you through it. So that is it for patents and trade secrets. And now we'll move on to John's part of the presentation, where he'll discuss trademarks and copyrights.
Thank you, Ed, for giving us that explanation of patents and trade secrets. As Ed mentioned, I'm going to focus on trademarks and copyrights and basically protecting your brand and your creative works that are used in your business. There's definite distinctions between trademarks and copyrights and trade secrets and patents. And an important one is trademarks and copyrights. Every company has trademarks and likely has copyrightable material, whereas some of you in the audience may not have anything that's raises to the level of seeking patent protection, or even is a trade secret where that is worth going into kind of deep protections, some of the protections that Ed kind of elaborated on. So in essence, trademarks and copyrights, every business has them. And the other difference between patents and trade secrets is that the trademarks and copyrights in general are less expensive to develop, acquire, and maintain than patents are. And that can be significant, especially for startup companies that are looking to acquire or signify that they have some intellectual property, either for investors or to the marketplace. Okay, Ed, the next slide, thanks. So what is a trademark? So a trademark is essentially your brand. It can be your company name, but not necessarily. It's many cases, it would be your company logo. It could be a product name. It could be other indicia of to consumers that provide some kind of recognition. For example, believe it or not, there are trademarks for sounds, smells, things of that nature. So there's a wide variety of things that can be considered trademarks. The key is that they provide some kind of indication of source of origin. I know there's a wide variety of companies in the audience. So you could have, an app, the name of the app. If you're developing a software application, the name of your software application is certainly a trademark. It could be, if you have a medical device, it could be the name of your medical device. It could be the house brand of your company. So there's kind of a whole slew of brands that can be protected and considered trademarks. So how do you protect a trademark? Well, the nice thing about being in the United States and being, the common law heritage of our legal system is that the user of a trademark gains trademark rights simply by using it in commerce, by selling products, offering products for sale, which is a great thing. But the downside to common law protection is that your protection is limited to the geographic area that you're using the mark. So if you're only using the mark in Philadelphia, you only have trademark protection in Philadelphia. So that means if someone's using the same identical trademark in California, say Los Angeles, for the same identical goods or services, you could have two companies having the same trademark for the same goods or services in two separate geographic areas. So that obviously can lead to problems down the road, especially as companies are looking to grow and expand throughout the United States. The other way to protect your trademark or your brand is through federal registration. And what that entails is filing a trademark application with the United States Patent and Trademark Office. There's going through the process and obtaining a federal registration. So how much does it cost to acquire these two methods of protection? For common law through use, there is no cost. Essentially, just by going out into the marketplace, you've acquired trademark rights. Where a federal trademark registration, there's two kind of levels of cost. There's, if you wanted to conduct a search to clear your trademark, the cost to do that can vary depending on how complex, how detailed, how comprehensive you want the search to be. So the cost can vary from, say, $800 to $1,500 to $2,000. Again, it all kind of depends on the level of comfort and kind of your risk tolerance as well. If you want to be able to sleep a lot better at night, not worry about having a third party out there that you don't know about, having a full comprehensive trademark search is probably the best way to do that. In terms of how long does it take to acquire a trademark? Well, again, common law rights are acquired as soon as you start using the trademark in commerce. With respect to federal registration, typically the average time now at the U.S. Patent and Trademark Office is about 10 months, but we typically tell clients 10 to 14 months. And that's the process it was significantly shorter prior to COVID, but because of COVID, it's kind of lengthened again to 10 to 14 months. The good thing though about a federal trademark application is your rights accrue, or you have potential rights accrue as soon as you file your trademark application, and those rights are then perfected once you get your registration. So in other words, once you file your federal trademark application, you've locked in your date of constructive use throughout the entire United States. So that means if any third party comes after you, your rights have seniority to the second company in time. And it also is important because if there is a third party out there, say in Los Angeles, that you didn't know about, by filing your trademark application, you've locked them into the geographic area where they're using the mark as of the time you filed your application. So that can be very significant, especially again, if you're looking to expand throughout the United States. A nice thing about, in terms of duration of protection, unlike patents, which have a very limited term, both common law and federal trademark registrations can theoretically continue as long as the mark is being used, and some other factor where you've kind of taken action that may kind of jeopardize your trademark. But as long as you're doing what you're supposed to be doing, theoretically your trademark rights can last forever. There are trademarks out there that are over 100 years old. In terms of federal trademark registration, you do have to maintain your trademark registration with the U.S. Patent and Trademark Office by periodically filing a declaration of use to show that you're still using the mark in commerce. And the reason why they require that is the U.S. trademark register is very crowded. And so they basically use this use requirement to kind of take out dead wood from the trademark register. And then a trademark there is a renewal period every 10 years after registration. So as long as you do those things, again, your trademark can last forever. Okay. So we get this question a lot. Well, if I have common law registration, why I'm not common law rights, why register the trademark? So a simple reason, a lot of times, the right to use the R in the circle is sometimes very appealing to businesses. It signals that you're out in commerce, and it signals, again, kind of a level of sophistication to the marketplace. And there's real legal advantages to having a federal trademark registration. There's a number of presumptions you get by just having a federal registration. As I mentioned earlier, that you get nationwide priority from your application filing date, which can be very significant. You also have third parties have constructive notice of your registration ownership by filing a trademark application, getting registration. And then you're presumed to be the owner of the trademark, and the trademark is presumed to be valid. That means if you go into court, the burden is on the infringer to try to prove that your trademark is invalid for whatever reason they come up with. Another very important reason to register a trademark is if you're going to be doing business online through e-commerce, or if you're going to be using social media in business, or if you're going to use the apps, the Google App Store, the Apple Store, for your app, having a trademark registration is virtually required in order to enforce your trademark in those places. In other words, eBay, Amazon, Twitter, Facebook, they won't take any action against an infringer unless you have a federal trademark registration. So if you see you or your company going to be in those type of environments, then you should have a federal trademark registration. Another reason is Amazon has developed a kind of a brand registry program, and there's lots of advantages to having a federal trademark registration if you want to open up your own store on Amazon, or if you want to be a provider to Amazon. It's not required to have a federal trademark registration to be on Amazon, but there are a lot of advantages within Amazon's system if you have a federal trademark registration. Also, if you're importing your product from overseas, and you're worried about potential, third-party knockoffs or infringers, having a federal trademark registration allows you to register with the U.S. Customs Office and potentially block infringers coming in from China or elsewhere who are just pure knockoffs of your trademark, things like that. And then I mentioned earlier that the R in the circle can signal kind of sophistication to the marketplace, but also signal sophistication to investors. If you're looking for angel investors or VCs, having your IP in order certainly signals to them that you are doing everything you need to protect your IP, and it also shows you're protecting an asset. Trademarks, and same with patents, can be used as security in loans and are frequently used in security in loans. So just by having that as an asset, there's certainly value in that. Okay, the next thing we're just going to talk about is what are the trademark considerations if you're an investor or if you are an entrepreneur getting your company ready to receive investments or to present yourself into the marketplace. The first thing I would recommend is certainly seek trademark protection through federal registration for your company name and any key products or service names that you're using. That doesn't necessarily have to be all. You necessarily have to get federal protection for every brand or mark that you use in the company, but certainly for your key marks that would be likely to be stolen or infringed upon or appear in domain names or social media or app stores, certainly register those trademarks. So another issue that comes up with trademark owners. A startup owner will file a trademark application as soon as they come up with an idea for a company. They may do that themselves. The problem is then later on the LLC is formed or the entity is formed, and the trademarks are never assigned to the proper entity. And in some cases, that could put the trademark validity in jeopardy if the trademark was not filed by the proper owner of the trademark. So that can be a real issue, especially when you're looking to bring investors or exit the company. And another issue, of course, is infringement concerns. Using a third party's trademark could open the company to trademark infringement, which could mean having to rebrand and potentially recall products from the marketplace or even pay damages. So the failure to clear your trademark can set your company back years, months, and potentially can jeopardize the entire company. So next, we're going to talk about copyrights. So copyrights are unique as well because they protect the expression, not the idea. So the copyright can appear in software code, it can appear in advertisements, it can appear, your website can be copyright protected, your logo can be copyright protected if it's creative enough. And in terms of how you protect your copyright, kind of similar to common law trademark rights, by creating the work and putting it into a tangible medium of expression, the author of that work has a copyright. However, if you want to enforce your copyright in court, you need to have a federal copyright registration. Without that, you can't go to court to enforce your copyright. In terms of cost, it's of all the IP that we've discussed today, copyright is probably the least expensive. In terms of filing fees, it's only about $55 to file a copyright application. And if you're the author, it's not a complicated process to file a copyright application. It can be more complicated if you are filing a large number of collective works or photographs from a website or something like that. But on average, the average cost to file copyright can be from as low as $55 if you do it yourself to $800 to $1,000, depending on the complexity of what you're filing. Again, in terms of acquiring, you have it immediately once you fix it to a tangible medium of expression. In terms of the copyright registration process, it's generally 2 to 4 months. It's all done online now, thankfully. And then if there is an issue of infringement, there are ways to expedite the process, but that certainly entails additional fees, especially government fees for that. And so what do you get when you have a copyright? Well, you have the right to reproduce your work. You have the right to create derivative works from what you've created. You have the right to publicly display and also publicly perform if that's a type of copyright you had. So there are extensive rights there. And for most people, the duration of the protection of your copyright is more than enough. It's basically 70 years. It's the life of the author plus 70 years, so or 95 years from publication for works for hire. So that in the vast majority of cases, that's certainly enough time for protection. So just wrapping up, the copyright considerations for investors and those looking to be invested in are, and this is an important aspect, and it's a critical aspect. If you're paying someone to produce your content, that does not mean that you own it. You merely get a license by having a graphic designer or software developer or a marketing person develop copy for you. You or your company do not own that unless it's been specifically assigned in writing to you by the author. So this comes up a lot, and if it's the one takeaway I would emphasize from my side of the program is to make sure that this issue is dealt with directly upfront before you pay the author, the original author, or you pay before your company becomes well known, because it's going to cost substantially a lot of money later to try to clean up these ownership issues, and it could if the other side is difficult, it could jeopardize some key aspects of your IP portfolio. On the kind of infringement side, there's a widespread misunderstanding that if a picture's on the internet, it's generally available to be used. It's fair use. That's not the case. If you're going to take a picture from the internet, you should take it from a company that provides or licenses photographs for that purpose. Otherwise, you run the risk of being charged with copyright infringement. And we see this frequently. There are companies or trolls out there who lure people into taking their photographs, and then they track them down through bots, and then they receive a cease and desist letter and end up paying a couple $1,000s to get out of this situation. So always either develop your own photographs, your own designs, your own copy, or license them from someone who has already developed them. And then, as I mentioned earlier, copyright registration is required for infringement. So if you don't have a registration, you can't go to court. So that was a very quick summary. We could spend substantially more time on this, but the goal of this was to kind of set the stage for the rest of the presentations at the Angel Venture Forum program. So on behalf of my colleague, Ed Barr, myself, and Volpe Koenig, thank you for your patience. And if you have any questions, our contact information is on the screen, and have a good day.